Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So, we received an interesting inquiry here on our YouTube channel. This has to do with theft with priors. Let's see here. My son was arrested of burglary. All right. In the past, he had other crimes of theft. He fulfilled all the terms of all his obligations. How will the old cases affect him? Well, first of all, let's talk about the burglary. You walk into a house with the intention to commit a felony therein. Under Penal Code Section 460, that's a felony, burglary, that carries up to 6 years state prison. And it's also a strike. It will be on your record for life. Now, the prior offenses will only affect you if they are less than 10 years old, or rather your son, if they're less than 10 years old. If they're more than 10 years old, those priors will not affect him. If those prior thefts, as long as they themselves were not strikes, if those prior thefts were in fact less than 10 years old, those would be priors, and any prior will be used against your son to increase the punishment. Now, it's not going to get beyond the maximum sentence, but in terms of negotiating the case, the DA will use those priors to give your son a higher offer, let's say. And not only that, but also the fact that your priors are thefts doesn't bode too well, especially if they're less than 10 years old, because if your burglary case were to go to trial, the fact that your priors were theft cases, those theft cases will be used as evidence to show the jury that you are somebody who has a propensity to be stealing, which would dramatically increase the probability that you would be convicted of that burglary. So it would probably, unless the evidence is so out of whack, it's probably not a good idea to take this case to trial, because those prior offenses, which are theft offenses, will definitely be used against you. And most juries who hear, oh yeah, this guy in the past was convicted of 3 other thefts, I mean, they're going to think you did it. So this is a case that you might want to just cut a deal with the DA's office, because the jury isn't going to look too kindly to those priors. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comments section below so that we may respond in the future with more videos. But if you've been accused of a crime and need representation in court, call us now for a free consultation at 1-800-862-7677 here in the San Francisco Bay Area. Once again, 1-800-862-7677. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.